Thank you for joining us today for the webinar on the 20 most frequently asked questions in employment law. Our speaker today is Nathan Overberg, and he is a shareholder with Allers & Cooney here in Des Moines. And he will address a number of different issues, obviously the 20 most frequently asked questions. And Nathan has a great amount of experience spending the majority of his time representing clients in all types of litigation in the state and federal courts, and both at the trial and appellate levels before many national, state, and local administrative agencies, handling claims that have to deal with discrimination, retaliation, wage claims under the Fair Labor Standard Act, et cetera, et cetera. So hopefully a lot of the things that we'll touch on today will keep you out of those predicaments, but at the same time lend you some expertise here so you've got someone to call if you do have issues. So without further ado, I'm going to turn it over to Nathan to get going here. Do know that we are recording the webinar, and there will be a rebroadcast of it available online after the fact. As we proceed today, feel free to type in your questions. There is a dashboard that popped up when you signed in, and you can type in your questions there on the right-hand side. If it's pertinent to what we are addressing at the moment, we will certainly take those questions. If it's something that we know we're going to get to later, we may just kind of set it on a back burner and address it as we proceed throughout the webinar. So without further ado, here's Nathan.
Well, thank you, Meg, and thanks for the opportunity to talk to all of you today. I look forward to giving you a 30,000-foot overview of a lot of different topics that come to my office frequently, especially from my smaller employers who may not have in-house counsel or a huge HR office. So we won't go into incredible depth, or we wouldn't be able to cover as many topics as we hope to cover, but I do hope to give you some overview so they can flag issues as they come into your office. So without further ado, the first question that I pose is one that comes up a lot, both in water cooler talk and through my office phone line. Is Iowa still an at-will state? And obviously that question assumes you all understand what at-will means, which is the general concept that unless an employee has an individual employment contract or a collective bargaining contract, a union member, that generally an employee can be terminated or quit for any reason, with or without notice or cause. The issue is, however, that although in theory we are an at-will employee state here in Iowa, the number of protected characteristics and activities which can give rise to a wrongful discharge cause of action continue to increase. For example, in the last few years, in addition to things that I'm sure you're all familiar with, that you can't terminate someone because of their race or their sex or their age, under Iowa law, you can not terminate someone because of their sexual orientation or their gender identity. Recently, the federal law even added genetic information to the list of characteristics that you cannot terminate someone for. And genetic information is defined broadly to include medical history or family medical history. So you cannot terminate or make employment decisions based upon that characteristic either. In addition to the statutory characteristics that are being added to the list of things that you cannot rely upon to make an employment decision, the Iowa Supreme Court is also expanding protected activity. Hopefully you understand that you cannot terminate someone, for example, who files a workers' compensation claim. Now the Iowa Supreme Court has said that if an employee complains about a violation or perceived violation of basically any law or regulation that deals with public health or safety or general welfare, that even if that law doesn't specifically protect the employee for registering that complaint, that if you were to terminate someone because they have registered that complaint, it would be wrongful discharge and subject your company to liability. As I point out on this slide, another thing to keep in mind is that the standard for proving that you took action because of a protected characteristic or activity is getting lower and lower. In many situations, all they have to establish is that that protected characteristic was a motivating factor in the decision. In other words, it doesn't have to be the determining factor. It only has to be one of many motivating factors in the decision. That lower standard makes it easier for an employee or former employee to bring the claim and to survive some preliminary motions that tries to get the case dismissed. So one lesson I want you to take from this is that although we are an at-will employee state, it is important that any time you make a decision to terminate an employee, that you should be able to articulate your legitimate, non-discriminatory, non-retaliatory reason for the discharge or adverse employment action. So you need to ask yourself, can I identify a reason that has to do with job performance or attendance or some other issue that I can then defend a claim where they try to allege that you terminated them for an unlawful reason. Our next question that comes up with some regularity is deducting from an employee's check or their last paycheck. For example, an employee walked off the job with a stapler. Can I deduct the cost of the stapler from her last check? Although I indicate on the slide that the answer is depends, I think the better answer is usually not. We have the Iowa Wage Payment Collection Act, which is Iowa Code Chapter 91A, which controls how an employer handles an employee's paycheck. And specifically, subsection 5 talks about the things that you may not deduct from an employee's paycheck. I'm not going to read through all of those, but I imagine there's at least one or two of you who will say, uh-oh, we've done that before. You cannot deduct under any circumstance from an employee's paycheck, for example, losses due to unintentional breakage of property, of company property, or lost or stolen property. You cannot deduct for losses due to the acceptance of bad checks or for an employee not taking enough action to stop the theft of company property. One exception here that is in the listed number 4 is that if you assign a particular piece of equipment to an employee and the employee signs acknowledging that particular piece of equipment, such as a laptop that has a particular serial number that's assigned to an employee, and that computer ends up being lost or broken, in that circumstance, you may be able to deduct the cost of that lost or broken property, but only if you have that specific property assigned to that employee and they sign an acknowledgement indicating that they've received that property and are responsible for it. And even in that circumstance, I'd suggest that you put on that written form that the employee acknowledges that if it's lost or stolen, that the amount of the lost or stolen property can be deducted from their paycheck. 91A.5 indicates when you can make deductions, and it's as required or permitted by state or federal law, for example, tax withholdings. Another thing that you can deduct is something that's by order of a court of competent jurisdiction, such as a wage garnishment order. And the final one is if the employer has written authorization from the employee to deduct, and this is the second part that sometimes gets overlooked. It also has to be for purposes accruing to the benefit of the employee. So it's not enough to just get a written authorization from the employee, but it also has to be something that accrues to the benefit of the employee. And I've given you some examples of those things that can be deducted: insurance, 401k, pensions, etc. And you will have access to this PowerPoint, and throughout there are some very helpful links that I would refer you to. So if you ever have questions about deductions or wage issues, this link at the Iowa Workforce page is very helpful. They have a frequently asked questions form that you'll see I refer to periodically through the presentation. So question 3, am I legally required to provide a break to my employees? Again, the answer to this assumes that you do not have a contract with the employee, or they're not subject to a collective bargaining agreement. But if they are not, then the answer is that generally neither federal or state law requires any type of designated meal or rest break for the run-of-the-mill adult employee. I would say, tell you that because often the issue comes up and employees say, well, I have a right to a 15-minute rest break. Well, unless there's a contract or a specific policy that you have providing them that break, the law doesn't necessarily require that you provide that type of break. You should be aware, however, that OSHA does require that you allow your employees to use the restroom as needed. Iowa law does have specific rules regarding breaks and hours for minor employees. And as you've hopefully already learned, the new healthcare reform law did amend the federal Fair Labor Standards Act that requires employers to now provide reasonable break time for new nursing mothers to express milk during the first year of that infant's life. And you need to provide a place other than a bathroom that is free from intrusion and that is private, in which that employee can express milk for their infant. There is an exception for employers with less than 50 employees if they can establish that it would cause undue hardship to provide the break or the location. Question 4, do we have to pay out unused vacation at the end of employment? Again, this is kind of water cooler talk. A lot of times there's an expectation that that is legally required. In fact, whether you pay out unused vacation at the end of an employee's employment depends upon what you have said in your policies or your letter of appointment or any contract you may have with them. You can establish as an Iowa employer any vacation policy that you desire. I would encourage you to specifically spell out whether or not you're going to pay out unused vacation at the time of termination. And again, you can decide from a policy standpoint whether you want to be generous and make that payout or whether you do not want to make that payout for whatever financial or practical reason you may have. The law is unclear what happens with respect to unused vacation if your policy is silent on the issue. So that's why we encourage you to make sure if you do provide vacation, that you have a policy explaining your vacation and also explaining what happens with respect to unused vacation. We'd encourage you when you craft that policy that you do not describe vacation as being earned or an entitlement because then the issue with respect to payout at the end of employment may get more confusing. Instead, we would suggest that you just talk about vacation that is available or that they're eligible for, and then talk about it as being something that they forfeit at the end of employment. Again, I'm citing to the Iowa Workforce FAQs, which are a helpful resource on this topic as well. The next few questions deal with investigating harassment complaints, and the answers are not dependent upon it being a sexual harassment complaint. More and more, there is an increased attention to something called bullying. Bullying is essentially concerted mistreatment of or continuous mistreatment of an employee, but it's not based upon their sex or race or age or another legally protected characteristic. So these answers, I think, should apply not only with respect to a protected harassment complaint, but also complaints of bullying, etc. So the question is, initially, do we need to investigate an anonymous complaint? How about if it's even just a rumor? this is a strong, unequivocal yes. If you receive information that unlawful harassment is taking place or an employee is being bullied, even if it comes in the form of an anonymous complaint or a rumor, you should do your best to investigate that complaint. Now, sometimes there will be an inadequate amount of information to allow you to do much of anything, but you should make an effort to talk to employees in general terms if anybody has any concerns or complaints or have witnessed anything under those circumstances. If you have an HR department, it's important that your supervisors are trained, that if they hear rumblings of this type of complaint, that they report it to your human resources professionals so that they can look into those complaints and decide the best manner in which to investigate. So the follow-up question to that is, who should perform the harassment investigations? Depending upon the seriousness and the details of the allegations, the position held by the accused, the company may use an independent investigator outside of the company. It can be a lawyer, doesn't have to be. You can retain legal counsel to conduct the investigation, and then that provides you at least one option, which is that you keep the contents of that investigation privileged as a work product or attorney-client privileged investigation. You may ultimately decide that even if the lawyer does the investigation, that you don't want to keep it confidential because you want to be able to show whatever government agency is looking into the matter that, hey, look, we did this investigation, we hired this professional, and this is what they found. But at least if you do have an attorney, that gives you the option of trying to keep the investigation privileged. Another option is to use individuals in your HR office to conduct the internal investigation. Often they've done a lot of these types of trainings where they learn how to do an investigation properly. I do have employers who have supervisors do the investigations. I got to tell you that can lead to some problems. There's a fear that employees aren't going to be open and honest with a direct line supervisor. Often those supervisors aren't as trained as an HR professional on how to do a proper investigation. So I would use a supervisor only as a last resort. If you have other available means, especially if you have someone who's trained in how to conduct these investigations, then I would defer to that option. Should there be an investigatory written report? It's, we think, often advisable to ask your investigator to prepare a written report that contains, at a minimum, a summary of the scope of the investigation and the investigator's findings and conclusions. If you hire an attorney to do this investigation, often you can ask them for an oral report first and figure out where they may be headed and then determine whether you want a written report. But again, for the reasons I previously indicated, often it's good to have a record of what was done with respect to the investigation and what those findings are, so that if it ever ends up in litigation, you can use that written report as proof to the government agency or to the complaining plaintiff that you did conduct a thorough and proper investigation and relied upon the findings in taking action or not taking action. What should be done with the investigatory file and any disciplinary action that results from your investigation? Well, generally we'd advise that the file be maintained as a confidential investigatory file. It should not be filed in either the complaining party's personnel file or the accused personnel file. It's just because often there's specific notes in there with respect to communications with other employees, employees' names, etc. And it's just not proper to have that type of detail in either party's personnel file, which under law needs to be made available to those folks upon request, and we'll discuss that in more detail down the road. If legal counsel was used to conduct the investigation, the materials and communications pertaining to the investigation should be filed separately and marked privileged and confidential pursuant to the attorney-client or work product privilege. So we would again say that you should segregate those files and properly mark them so that anybody who happens to stumble upon them understands the privileged nature of its contents. If you do take disciplinary action as a result of the investigation, obviously any disciplinary action forms should be filed in the accused personnel file, so you have a record of the action that you've taken. It's important that that disciplinary form is presented to the accused, and often we suggest that that is signed off by the accused so that if there are further issues down the road, you have proof that the discipline was explained to and acknowledged by the accused. And we often talk about progressive discipline, and this is an example where that can come into play. So if you have an employee, for example, who your investigation reveals has a habit of telling off-color jokes or talking about their sex life in the office, and you determine it's not severe enough to terminate them, but you do want to document that you're going to discipline them with a written warning or a couple of days suspension, etc. You can document that, and then if it is one of those employees who simply can't learn their lesson and they continue to behave in that manner or engage in more severe harassment or bullying down the road, if you have the initial discipline documented, then the next time around you can go ahead and terminate or take more severe disciplinary action. The next question is, should we ask for a release if we pay severance? What I've found, especially with some of my smaller employers, is that you're often generous out there, and will, even if someone is being terminated, it may be for less egregious reasons than, for example, a founded sexual harassment charge, and you may agree to pay them a couple weeks severance. And the question often comes up, well, what do we get in exchange for providing that to them? And often I have to say, you should consider getting a release, because there's nothing more frustrating than working through the disciplinary or discharge process, deciding to be generous and providing them with a little bit of severance pay, and then having that same employee on down the road turn around and see you related to that termination decision. So some of the things that you should consider in deciding whether or not you're going to ask for a release in exchange for the severance. And a release is simply a written form that says we're providing you with this payment that we're not otherwise required to pay you, and in exchange we're asking you to release your claims, and that you cannot come back and sue us related to your employment or the separation of employment. So consider your firm culture and historic practice. Do you, as a regular matter of course, provide this severance? Have you ever asked for a release in exchange? Consider the amount of severance that you're providing. If it's a couple weeks or less, sometimes it's not worth the effort to have a release put together and asking them to sign it. Another cost to consider in the cost-benefit analysis is if you ask for a release from an employee, it's more likely that they're going to take that release and consult with an attorney. And if they go consult with an attorney, they may come back and say, hey, now that I've talked to an attorney, he's telling me that you didn't pay me overtime, or you improperly deducted from my paycheck, or that I'm sure you're firing me because I filed a workers' compensation claim. So if you are encouraging them to go or to sign a release, they may get an attorney involved, which may result in the initiation of legal action that may not have otherwise occurred. In fact, if an employee is over 40, most of you are going to want to try to get a release of an age discrimination claim. And there are at least two sources of an age discrimination claim. One is the federal ADEA, or the Age Discrimination in Employment Act, That applies to any employers with 20 or more employees. There's also an Iowa Civil Rights Act claim, which would apply to anybody with 4 or more employees. But in order to release the federal claim, so if you have 20 or more employees and you want someone who is 40 or over to release an age discrimination claim, you have to comply with what's called the Older Worker Benefit Protection Act. And that has a lot of bells and whistles that your release has to include in order to get a valid release of that age claim. And one of those requirements is that you, in writing, instruct the employee to go see an attorney before they sign the release. So I wanted to point that out to you. If you do go down the path of seeking a release and you want to get a release of the federal age discrimination claim because the employee is over 40 and you have 20 or more employees, make sure that you're aware of all the bells and whistles. Telling someone to go see an attorney is just one of them. You also have to give them 21 days to consider the release, 7 days to revoke, etc. So if severance is 2 weeks or less, you may want to do a cost-benefit analysis based upon some of the things I've mentioned above and determine whether it's worth the trouble. If severance is 2 weeks or more, consider it. It may be something that you get in exchange for your severance payment that prohibits or prevents future litigation of that decision. The next question is one that often comes up, again, in the backyard, even more so than calls to my office. I have a lot of friends who are sales folks or in other positions and say, well, they're asking me to sign a non-compete. Is it really enforceable? This applies to you as employers in 2 ways. The answer is yes. A non-compete in Iowa, if properly drafted, is enforceable. So if you have a potential employee coming to you saying, hey, I have this non-compete with a former employer, but I'm sure it's not going to amount to anything, you should say, well, Nathan Overberg said that we should at least look into it because it may be enforceable. So in order to be enforceable, the agreements simply need to be well drafted and narrowly tailored with respect to time. If it's anything over 2 years, then it may not be enforceable to that extent. Geography, is it limited to kind of your sphere of influence that the employee and employer have, and the nature of the activities that are being limited. If you're seeking to utilize a non-compete with respect to your workforce, I would encourage you not to use a standard form agreement for every employee. Salespeople are different from service people, and your agreements should be tailored to the different positions and duties, etc. And your agreement should only be as restrictive as is necessary to protect your particular interests. If you only do sales in a 3-county area, then your non-compete should probably be limited to that 3-county area and not expand, to a 3-state area. For example. But what I wanted to take away from this is that I don't want you to go away thinking that non-competes are unenforceable as a matter of course. In fact, they are enforceable to the extent that they are properly drafted and put together. Question 11, can we drug test our employees? The answer to this question, I'm going to assume most of you are private sector employers, and in that case, you're going to be controlled by the statute. If you're a public sector employer, then you're also going to be controlled by the Constitution with respect to the nature of any testing that you do. But you can do drug testing, but you have to understand that Iowa does have a statute that is very detailed, and before you implement drug testing, make sure you get familiar with or get a professional consultant or attorney involved to make sure that you have all your ducks in a row before you roll out your drug testing policy or start drug testing your employees. The section is Iowa Code Section 730.5. On the bottom of this slide, I give you another link or website where you can find some useful information that summarizes the requirements of the Iowa Code. But generally it restricts when testing can be done, pre-employment, reasonable suspicion, post-accident, and random. It controls how each type of testing is to be performed. It requires that you have a written policy that lays out when you're going to test and how you're going to test, and that you distribute that to the employees before the testing occurs. It requires kind of a standard response to a positive test. It requires that you train your supervisors on the drug testing policy and procedures. And it requires you to maintain an employee assistant program or a resource file where workers can access help for substance abuse. And this is not an exhaustive list. There are other requirements before you can start drug testing. Now, even if you don't have a drug testing policy, it doesn't mean that you have to ignore evidence of illegal drug use or intoxicated or impaired work. You do not have to have a positive drug test in order to take action based upon perceived or documented illegal drug use or impaired working. And be aware that if you do do drug testing and get a positive result, not only are you going to be challenged on whether you properly complied with 730.5, but even if you did everything right, an employee may pursue a variety of different types of claims against you, some of which I've listed on this slide, which can include, alleging that you took action based upon a protected disability, such as alcoholism, which is a protected disability. They could bring that claim under the Americans with Disabilities Act if you were taking action solely upon their status as an alcoholic, as opposed to again, misconduct based upon intoxicated work. They could bring another one, a claim may be brought for invasion of privacy or for intentional infliction of emotional distress or for defamation, for example. If everyone knows the drug testing is going on and then you, when the results are coming in, are escorting people out with security, etc., they could attempt to bring a defamation claim that you were indicating that they were a drug user, etc. So I don't say that all of those claims would stick. I'm just saying that they are the types of claims that could be brought as a result of pursuing drug testing. It's not my intent to tell you not to drug test. I'm just trying to tell you that if you're going to do it, make sure you get your ducks in a row under 730.5 in advance, get your policy in place, understand your limitations, and understand that you don't have to overly rely upon drug testing results. Instead, you could, if you have evidence of illegal drug use or intoxicated or impaired work, you can take action based upon that without going through the drug testing process.
We do have a question that came in, and I'll just take a moment and have Nathan elaborate on this. The question was, if an employee looks intoxicated, does the employer have to take this person to the facility to have them tested? And then if that person is positive, does the employer have to take them home, or how do you handle that?
Sure, it's a great question, and it goes right into what I was saying. If you have evidence and have a reasonable belief that the person is intoxicated at work, and you have a policy that prohibits someone from coming to work intoxicated or impaired, you can discipline them for doing that, regardless of whether you engage in the testing process. As long as you have credible evidence to indicate, for example, not only do they look intoxicated, they have slurred speech they've never had before, and for example, which has happened for one of my clients, you find a fifth of vodka in their drawer, you can take action based upon that behavior without getting a positive test. Whether or not you take them to the facility to get tested is going to depend upon the nature of your policy. If you have what's called the reasonable suspicion testing laid out in your policy, and you've properly trained your supervisors on determining whether there is reasonable suspicion to believe that they are impaired, and that would, the the law even lays out what qualifies as credible evidence of a policy violation. So if you have the policy in place, you have your supervisors trained to determine whether there is reasonable suspicion to believe the employee is impaired, then yes, if you want to, under your policy, take that employee to be tested, that you should do that, and I would encourage you to transport them to the testing facility, because if you believe they are intoxicated, I would not encourage you to have them drive themselves off-site. And if there is a positive test, same thing applies. You don't necessarily have to drive them home. There may be other options. You may have to have the employee call someone for a ride, a taxi, or whatever may be available. But I would agree that if you have a positive test on that I wouldn't send them driving home. The next question on my list here is, should we contest a former employee's claim for unemployment? And I raise this because there are some employers who just as a matter of course protest everything. And one reason not to do that is similar to the conversation I had with you with respect to seeking a release. If you contest a former employee's claim for unemployment, it makes it much more likely that that employee is going to be mad, frustrated, go to an attorney, say, how can they do this? I have a right to my unemployment. And that employer, or that attorney will sit down with that individual and not only discuss the unemployment claim, but will start to look into, again, your payment practices, your overtime practices, whether they feel like they've been discriminated against, wrongfully discharged, etc. So I'm not encouraging you to always avoid protesting unemployment. I'm just telling you, give it some rational thought and determine which cases are appropriate to contest and which you should just not protest. So this is not known by all the employers, but the presumption is going to be that that employee, especially if they were involuntarily terminated, the presumption is going to be that they get their unemployment. The exceptions are if the employee voluntarily quit without good cause attributable to the employer. So again, it's not every voluntary quit that is going to disqualify the employee from unemployment. If they come in and say that they quit because you created an intolerable work environment, or they quit because you substantially changed their terms of employment, you reduced their pay, you made them work from a different site, you materially changed their duties, all of those could be what is called good cause attributable to the employer. And if the employee quit for that reason, they still may be eligible for unemployment. If it's an involuntary termination, the question is going to be, did the employee engage in misconduct? Misconduct is not simply poor performance or even poor attendance for that matter. It's got to be a deliberate act or omission that is a detriment to the employer. And I mention that because if you do contest one, what's going to be very important is that you explain to the Unemployment Commission that you have an express policy prohibiting the behavior that the employee engaged in, and that employee was aware of it. If you can show that you have a policy and the employee was aware of it, either because you had a policy or they had previously been written up for the same behavior, etc., then you're in a better position to show that their most recent act was a deliberate act or omission, and you have a better chance of establishing misconduct. As I mentioned, some other things to consider when determining whether to contest is, will contesting further increase the animosity, thereby increasing incentive to consult with an attorney? Given the high standards that the Commission will apply and the presumption that the employee will get the unemployment, will you succeed in thwarting the claim? Can you afford, on the other side of the ledger, can you afford the impact of a successful claim on your contributions? If you're thinking, well, maybe I should just allow the employee to get the unemployment, you do have to consider how that's going to impact your future contributions toward the fund. I do want to have you keep in mind that an adverse finding with respect to the unemployment claim, in other words, a finding that the employee did not engage in misconduct, that's not a binding judgment or conclusion with respect to the appropriateness of your decision or the legality of your decision, and it's not going to be binding in any other proceeding with respect to a wrongful discharge cause of action. So keep that in mind. We all want to win anytime we go through the effort to protest, but if you do, if there is an adverse finding, it's not a binding judgment or conclusion or order with respect to the appropriateness of your decision. It just means that decision maker at the unemployment office decided that you did not establish by preponderance of the evidence that the employee engaged in misconduct as defined by the unemployment regulations. The next question is, what if an employee asks for a copy of his or her personnel file? This is controlled by Iowa Code Chapter 91B. It's right next to the Iowa Wage Payment Collection Act, which is 91A. You must allow an employee to have access to their personnel file. You also have to allow them to obtain a copy of their personnel file. The personnel file includes their performance evaluation, disciplinary records, information pertaining to the employer-employee relationship. I do explain some of the limitations below. You can set the time when the employee is going to come in and view the personnel file. You can have a representative of the employer be present to make sure that the employee doesn't mess with the file. If the employee wants a copy, you can charge a reasonable fee, which is defined by the statute as basically what is reasonable with a third-party vendor copy costs. An employee is not entitled to access their employment references that were written for the employee. So there are some limitations with respect to the access to the personnel file, but generally a current employee, you do need to provide access to their personnel file. There is a question with respect to former employees. The law 91B specifically applies to current employees. There is one case out there that says that the law does not apply to former employees with respect to getting access to their personnel file. But what I often discuss with my client is this a fight worth having? Is denying a former employee a copy of their personnel file, again, going to be something that just increases animosity, increases the likelihood of litigation, et cetera, or would we just be better off providing them a copy of that personnel file? But that is something for you to give some rational thought to on an individual basis. Something that comes up frequently, usually after the fact. I don't often get this question proactively to avoid an issue. Can a supervisor maintain a separate supervisor's file? What we find out usually after litigation starts is that a lot of supervisors do. So then we have to deal with the consequences of that. So the purpose in me raising this issue is to give you all an opportunity to think about this issue, and to the extent you want to regulate it internally, that you do that. Supervisors' files are going to be discoverable during litigation. So if you are in a lawsuit and the other side wants to see that supervisor's file, they're going to get access to it and get to review it. And the problem with a supervisor's file is often it is not, sometimes it's not even known about by human resources, but often it's not reviewed by the human resources, and there can be some things in that supervisor's file that we really wish weren't in there. You want to make sure that there's no health-related information in a supervisor's file. That should be kept confidential, or must be kept confidential, in a separate HR file. So any health information should be kept away from the supervisor's file. Make sure that the supervisor's file does not contain the only copy of final disciplinary materials or evaluations. Often we find unsigned evaluations or unsigned disciplinary forms or training acknowledgments, etc., in a supervisor's file. All those things should make their way to a HR file, and if that happens, then the HR folks are going to make sure that they're actually signed and properly completed. If there is a supervisor's file, we've had quite a few arguments with current employees about whether they get access to those under Iowa Code 91B that we just discussed. So be aware that the supervisor keeping a file may subject you to that conflict as well. So I would encourage you, to the extent that you have an HR professional or an HR office, that they're involved in deciding whether separate supervisor files should be maintained and what should be included in those files. What is a litigation hold letter? A litigation hold letter is something that you will get from your attorney once litigation is reasonably anticipated. And the reason for litigation holds, they're relatively new, the last 5 or 6 years, for example, is because of the proliferation of electronic documents, emails and Word documents and text, etc. And some of these things get automatically deleted as a routine function of your IT system. And once litigation is anticipated, any relevant information needs to be saved. It cannot be deleted either intentionally or through these routine mechanisms. So once litigation is anticipated, this letter is going to explain, hey, employee X is bringing this type of claim. This is broadly what we think is relevant information, emails concerning the investigation or the discipline, etc. Make sure you go search for those, put them, make sure you're searching not only on your personal laptop, but your work mobile phone, etc., intelligent devices, flash drives, DVDs, etc. Make sure all that information is searched for on those locations, and if you find one, copy them to a particular file where they're saved and preserved and don't get accidentally deleted. So when do we have to initiate a litigation hold? I mentioned this kind of in passing. It's whenever litigation is reasonably anticipated, and that can be when someone files an actual lawsuit, or you get a civil rights complaint from the Iowa Civil Rights Commission or the EEOC, or you get a demand letter from an attorney, or any type of correspondence, even from the former employee threatening litigation. Once we get that, then it's important that we do our job in preserving any physical files and any electronic documents, including emails, etc. And then the next slide explains some of the things that need to occur once you get that litigation hold letter, which I've tried to run through here with you. The next question is, do I have to pay my employees for the time they are on call? A lot of us think of on-call time, maybe only applying to firefighters or police officers. I got to tell you, a lot of folks consider themselves on time. They can be your retail managers, your IT professionals, etc., who basically have coverage over the weekend with respect to responding to any issues or problems. Do I have to pay those folks for the time they are on call? Well, the first thing I'll mention to you, obviously I'd start with it depends, but some of your folks are going to be what's called exempt, and that's a topic that could take hours by itself, but I want you to be aware that simply because you have decided to pay an employee a salary does not mean that they are a legally exempt employee and therefore not entitled, for example, to overtime or minimum wage, etc. Being paid on a salary basis is one part of the test, but there's also a function test where you have to decide whether under the law and the legal regulations the employee is performing the type of work that exempts them from overtime. If the employee is not exempt, then they're entitled to minimum wage and to overtime for any hours worked over 40 in a work week. And so this issue of on-call time comes up often with your non-exempt employees. In other words, they're entitled to overtime, and usually you're paying them on an hourly basis. And the standard is going to be, are these folks engaged to wait or waiting to be engaged? If they're just waiting to be engaged, they're free to go about their business. They can go to the store, they can go to their kids' sporting events, and they only get engaged to perform work for you if they get a call. Then while they're waiting, they're not on the clock, and they're not entitled to pay for that period. However, if they're engaged to wait, if that employee has to stay, within a mile of the office, or they can't leave their home, etc., the more you restrict them, the more that you are engaging them to wait, and you're going to have to pay them for the time that they are waiting while they're on call. I know that's a kind of a squishy standard, but that's the best that we have from the statute and the regulations. So if you have questions about your on-call folks, I'd suggest you contact your counsel to try to figure that out, because it can become an expensive bill to pay if you've had somebody who is on call for every other weekend for a year, and it ends up that they should have been being paid for that period. That could all end up being overtime that is owed to those folks. Question 17, is when can I make deductions from an exempt employee's pay? So that's why I gave you a brief overview of what an exempt employee is. An exempt employee needs to be paid on a salary basis and meet the duties test I mentioned. And if that's the case, then as long as you pay them a set salary per week that is over the minimum, $4.55 per week, then you don't have to worry about tracking their hours and paying them overtime for hours worked over 40. But sometimes there become situations where you want to deduct the exempt employee's salary. So if usually they're earning $1,200 a week, and this week you're going to deduct 1 day's pay, and so they're going to make less than that $1,200 a week, you can run into some trouble. If you don't follow the law and you make deductions from those exempt employees' pay, then they might lose their exempt status. And then they start to become entitled to overtime for all the work that they've done over 40 hours in a week. And you know some of your managers and exempt employees can work a lot of hours. You may have to pay overtime for that time if you ruin their exempt status by improperly making deductions from their salary. So I provided you a list of those times when you can deduct from your exempt employee's salary. For the sake of time, I won't read through them all, but be very careful where it talks about in this list a suspension of 1 day or more. That's telling you that you can only do it if it is a 1-day unpaid suspension. You can't do a half day in those particular circumstances. One that maybe is common sense, that an initial or a final week of employment, if they don't work a full week in their first week or their last week, you don't have to pay them a full week salary. There are situations where you can do disciplinary suspensions of 1 or more days, or if somebody's taking 1 or more full days of leave for personal reasons other than sickness or disability. Are there topics to avoid while interviewing applicants, and why? I'm going to try to run through this one quickly as well, because I think it lays out some of the other laws that are out there that you need to be aware of. For example, don't ask about a father's recent health issue. If you know the employee and you know the employee's father has had some recent heart issues or something, you don't want to, in the interview process, ask about those issues, because it could be a violation of GINA, which is the Genetic Non-Discrimination Act, the Genetic Information Non-Discrimination Act I mentioned earlier. So be careful with respect to family health history questions. Be careful about asking an individual with a noticeable limp what happened during the interview process. This could create ADA or Iowa Civil Rights Act problems, because they prohibit pre-employment medical inquiries, which that could be considered. Be careful about asking interviewees if they have ever been arrested. The EEOC frowns on making decisions based upon arrests as opposed to convictions. So be careful about asking about arrests as opposed to convictions. Be careful about asking the applicant what year he or she graduated in, because if you start talking about graduation dates, that can then lead to inferences about how old that individual is, and if they don't get the job, they can say, well, they were just trying to ferret out how old I was and make a decision based upon my age. I mentioned earlier that some of these laws only apply to certain employers, and I just want to throw these out there to you too. The Age Discrimination in Employment Act, as I mentioned, was 20 or more employees, and then you're a covered employer. Most other federal discrimination laws is 15 is the magic number, 15 or more employees. The Iowa Civil Rights Law is 4 or more employees, and then you're covered. The FMLA is 50 or more employees within a 75-mile radius. Some of the other questions to avoid asking, asking a female applicant who takes care of her young children. Unless you're asking the male applicants the same question, there can be a perception of sex discrimination. Be careful about asking an applicant who has a significant accent where he or she is from originally, because you can't make decisions based upon national origin. And asking someone with many children if they are Mormon or Catholic or some other religion, because that could open you up to a religious discrimination claim. I know I am running short on time here. We're about done. I'm going to encourage you to look at the additional slides for written material, which I think is helpful to you. Remind you, if you have any questions, to go ahead and post them. You can I'll try to answer them in the last few minutes here. Otherwise, I don't know if we have a setup here where Meg can forward those to me and I can respond by email, but that might be a possibility too, so I'd encourage you to go ahead and post your question if you have a question. What I should know about the FMLA, there's just so much there that I can't even do it justice in the last few minutes. What I want to point out is just some red flags for all of you. If you're a covered employer, have the requisite number of employees, and an employee is eligible, which means that they have been with you for at least a year and have worked 1,250 hours in the last 12-month period, then you have to be able to provide them with 12 weeks of leave. It can be unpaid, and that needs to apply if they give birth to, or their wife gives birth to a newborn child, if they have adopt a child, in order to care for a spouse, child, or parent with a serious health condition, the employee's own serious health condition. And then there are a couple of other situations with respect to folks in the military where they get leave. If there's an exigency, someone is going into active duty, or if you need to care for an injured service member. So if any of those issues come up, somebody needs leave because they're having a child, adopting a child, their parent or child is sick, they have their own serious health condition, or there's a military circumstance, I just want you to have a red flag. Hey, is this an FMLA issue that we need to make sure we're complying with the Family Medical Leave Act? Because if you don't, we're seeing more and more of these types of lawsuits. The next slide explains a serious health condition. It's pretty detailed, but it's not every, sick day for a cold. But it does cover a lot of situations, especially if there are 3 consecutive days missed. I just want to point out on this slide, I don't want it to be misleading. The first bullet point under C, employees are required to provide 30 days of advance notice of foreseeable leave, like if they're having a knee replacement surgery. But if it's not foreseeable, then they only have to provide you notice as soon as reasonably practicable, which is kind of, excuse me, a fluid definition, but usually it's within the day or the next day that they have a need for a leave. They're supposed to let you know about it. So if you receive any information suggesting an employee is missing work or is expected to miss work, because of their own serious health condition or that of a family member, make sure you get your HR professionals or your legal counsel involved with respect to the FMLA. But this would apply if you're a covered employer and have the requisite number of employees. Make sure you don't take any action against someone who utilizes FMLA leave, and don't interfere with their ability to take FMLA leave, or that could lead to legal action as well. And finally, what should I know about social media? Well, you should probably know a lot more than I do about it and how it works, etc. But what I can tell you is it is becoming a hot button issue out there. Obviously, your harassment or bullying policy should be broad enough to cover coworkers who are harassing someone or engaging in disruptive activity through social networking. Make sure people know to look into those types of complaints if they are raised. But you have to be careful. There is another side to the issue, and that is employees are allowed to engage in discussions amongst themselves with respect to concerted activity, which is a National Labor Relations Act provision that includes anything to do with the terms and conditions of their employment. So if, for example, you have 3 employees in a Facebook chat talking about, boy, this supervisor is a jerk and we're underpaid, you could not discipline them for that type of discussion, regardless of whether you're a union shop. The National Labor Relations Act applies to all employers, even if there's no union present, to the extent that you cannot discipline or take action against employees for engaging in concerted activity, which can be quite a bit of Facebook chatter, etc., about their terms and conditions of employment. So those are the 2 topics on social media I wanted you to know. And I know I'm out of time. I don't know if we've had any other questions pop up. We don't see any. I'm going to turn the phone over to Meg, and thank you all again for your time over your lunch hour.
Well, thank you very much, Nathan, for that great information. It's funny, you know, the social media question number 20 here probably wasn't even an issue 5 years ago, so things certainly do change. It sounds like we all need to go back and dust off our policy books, or maybe craft one if we don't have one. And a couple hours of prevention can go a long way here. So thank you for your time and attention today. As I mentioned, this will be available online later today along with copies of the slides. You will get a link to that in a follow-up email that comes from the webinar software, so you can be on the lookout for that. If you do have questions, feel free to reach out to myself, Meg Fitz at the Partnership, or Nathan over at Allers & Cooney Law Firm. Thanks, and have a great day.